Hello and welcome to the daily newspaper analysis. Today we shall be discussing the newspaper of the 26th of March. But before we begin, please consider my sincere apologies for delays in uploading our videos in the last 1 week. I have been suffering from some health issues. Because of that, the videos got delayed. But I assure you that from now on, videos will be coming up regularly. So on that note, let's continue. Coming to the first article, controlling the machine. Now the context here is with regards to the need for a data protection law. Time and again we are seeing that articles are now coming on data protection law. This is in the backdrop of the Cambridge Analytica case, which you all know. This Cambridge Analytica is a private firm in UK, and this firm has leaked the data of 50 million Facebook users. This data was something that was gained by this firm, and this data was used to draw analysis about predicting election results in US. Also, it is said that this firm has been accused of manipulating the electoral results or the referendum that was done with regards to Brexit. So in all these major events, this company is said to have played a role. This is important for India also because Indian political parties are also the clients of Cambridge Analytica. So that is something that you need to know in the background aspect. Now coming to the issues which have been discussed. The first issue is with regards to the internet user base. Now here you should know that India has the second highest number of internet users in the entire world. Not only that, the internet users in India are more affiliated towards global giants. For example, in the sector of social networking, Facebook is the major giant in India also. Also when it comes to search engine, Google has completely taken over. Also when it comes to online commerce, Amazon is the major giant who's much more active and much more popular in India. So in that respect, India is much more dominated by global companies. Also the local homegrown technology sector which is developing in India, this sector too is following the strategies and the corporate culture of these global companies, and as a result of which the ethics and the values of these companies is what is coming in the internet users of India. So that is something that has been analyzed here. Another issue is with regards to the personal data. Now, personal data is the fuel of all these companies. For example, Facebook doesn't charge a single penny from a person for making an account on Facebook. But what is the source of Facebook's income in that case? The source is the data that Facebook is getting. Because of this data, Facebook is able to garner a large number of advertisements, and this is the source of revenue for Facebook. And as a result of which, personal data is the fuel for these companies. And not only that, also for the government's personal data is something that is very much important. As we are seeing in case of India also in the Aadhaar issue, personal data is something that even the government is seeking. So personal data, the editorial here is saying, is not merely a fuel, rather he's taking it a step forward and he's saying it is the air now. That means it is omnipresent now. So that is something that has been analyzed. Another thing is with regards to the data protection law in India. Now, though digital technology is something that is deeply entrenched in the lives of every Indian, the issue is that in India there is a curious omission of comprehensive enforceable data protection law. That is the statement which has been given in the editorial. Also, the act that is at present, which is there, the law which still exists is the IT Act of 2000, and this law is deeply inadequate to protect the data of the users. So in this respect, definitely a data protection law is something that is warranted. Now in this context, what has been analyzed is the General Data Protection Regulation, which is known as the GDPR for short. This is the law which has come in the European Union. And the editorial is making a case that this law is a model which even India should adopt, because this is a law which is focusing on the individual rights above the requirements of the states as well as the private industry. So this is something which is in spirit with India's laws also. The right to privacy, for example, said that the citizens' rights are above the rights of the government. So in that context, one can analyze that indeed this law can act as a model law for India. Also, this law provides for some exceptions. These exceptions will allow accessing personal data to both the government as well as private companies. But these exceptions are something that are going to be guided by two principles, and these are the principles. The first is the principle of necessity, which means that a government institution or a private company can use data depending on the necessity. So this is one criteria. The second criteria is the criteria of proportionality, which simply means that advantages due to limiting the privacy right are weighed against the disadvantages of this. So these are the two bases on which the GDPR law is something that has been formulated, and it is this principle that even India should adopt in its law. Now, even if you do not mention about these principles in your answers, at least you can make a statement or you can make an analysis that India can take from the European Union's law. So that is going to be the importance here. Another thing which has been analyzed is with regards to some safeguards. Now, what has been advocated here is that a transparent system of data processing is something that is required. Also, the users, that is the Facebook users or the Google or Amazon users, should be very much aware as to what is being done with the personal information that is being collected. Not only that, the data that is being collected should also be used for the purpose for which it was collected. This is an issue of a contract. The data in this case, there it has been leaked of 50 million Facebook users, was collected at some other pretext, but it was used for some other reason. So this kind of a breach of trust is something that should not be done, and these kind of safeguards is what should be ensured. So that is something that has been analyzed here. Another very important aspect which has been discussed briefly in this editorial, but which will become important for us, is the issue of rights versus limitations on rights. Now, what you all know is that in the fundamental rights that we all have, there are limitations with regard to almost every single fundamental right. And this is also one of the biggest criticisms against the fundamental rights. Now, what is being seen is that governments often have a tendency to expand the limitations on these rights. But with developing democracy and with maturation of a country, what is important is that the rights is what should be expanded and the limitations on these rights should be minimized. So that is the policy which has been advocated in this particular editorial also. Another thing which is very important is with regards to the challenges. Now, definitely there are some challenges with regards to this particular data protection law, because this is one law which has to fight against powerful companies. These are global giant companies, against them, and as well as against the governments. So the data protection law has to protect an individual citizen against major companies as well as governments, and that is the primary challenge. Another primary challenge is that the law is not merely something that has to be written down or merely a verbal commitment, or for that matter only a legal commitment. What is required is that an environment is something that is made where right to privacy is something that is respected. Even the right to privacy is now declared as a fundamental right. The culture in our country is something which does not respect the right to privacy of citizens, and this is one major cause of concern. This is a behavioral change which needs to be brought with regards to this particular law. So that is something that has been analyzed here. Another thing which is very important here is that India in this regard can become a global leader. Already an example of net neutrality is something that has been discussed. Now you should note that despite the fact that countries like US also have taken some retrogressive steps in this regard of net neutrality, even despite that, India has taken some major steps, and India is one of the most open countries on net neutrality. So in that context, what has been analyzed is that similarly India should also come up with one of the best data protection laws, and it should become a global leader. So that is something that has been analyzed. Another thing which has been analyzed is about the idea of social control. Now this is also a keyword which you can use. A quotation is what has been given by Pandit Jawaharlal Nehru. The quotation is that I believe in the machine and would have it spread in India, but I also believe in the social control of it. So this term was something that was used by Pandit Jawaharlal Nehru when he was talking about technology. So definitely there is a need for social control, and this is something that can be achieved by the civil society. At present, what has happened is that the user-oriented data protection law is something that is missing, and every single citizen is fearful about online safety and is having a sense of loss of control. So this is something that needs to be restored back, and that is the idea of social control. This issue about data protection law is something that is going to be very, very important for 2018 means. In the science and technology aspect, in the social aspect, somewhere you will definitely find a question with regards to this. So that is going to be the relevance. Now coming to the next article, the need for special attention. The context here is with regards to judicial inefficiency due to huge backlog of cases. Now, basically this editorial is discussing about the different types of alternate mechanisms which have been developed for doing away with this backlog of cases. In that context, a special focus is what has been given on the special courts. So that is the primary focus of this editorial. Now coming to the issues, first and foremost, an understanding is what is going to be vital about what is a special court. Now, a special court is a court which is established under a statute. This word statute is something that is very important for us to write whenever we are talking about special courts. You can remember it from the S, which is common in both. Now, this is an idea which makes it different from fast track courts. This idea that it should be a part of a statute simply means that whenever a law is made, for example, the Criminal Law Amendment Act was something that was made. If in that one particular law, there would have been a mention of a special court for dealing with cases related to crime against women, then that would have constituted a special court. So what is important for a court to be designated as a special court is that it should be mentioned in the law itself. So that is what special court is. Now coming next to the fast track courts. Now a fast track court is something that is formed specifically to deal with the judicial backlog. There is no need for a specific legislation for a fast track court. This was something that came up as an idea by the 11th Finance Commission. So this is something that you should know. And also one thing that is important here is that this is an executive scheme. The legislative has no role to play in formation of fast track courts, whereas the legislative has a major role to play in the formation of special courts. So that is one difference that is there between them. Now coming to the issue of lack of research and analysis. Now what the editorial is discussing is that though this idea of special courts is something that is novel, but the issue here is that there is inconsistency in legislation and operation. Also there is a lot of confusion which is there often in the law itself. For example, terms like establishing a special court or constituting a special court or notifying a special court are used interchangeably. And these terms are very much different. And this is something that creates an ambiguity, and this results in difficulty in processes of appointment, budgetary allocation, infrastructure settings. So this is one major challenge which special courts are facing, and this is something that needs to be done away with. And this can only be done away with if there is more research and analysis that is done with regards to special courts. So that is what has been analyzed here. Another issue is with regards to an unclear legislative intent. Now the intent behind special courts could be twin. One intent could be that special court could be set up to deal with a special issue. For example, in the prevention of sexual crimes against children, in that particular law, a special court was something that was suggested. Now this special court could be designed particularly to deal with a specific issue. Or the second benefit of a special court could be speed. That means the judicial backlog, to decrease that, special courts could be set up. But the issue is that there is an unclear legislative intent. For example, in the Prevention of Corruption Act of 1988, there are much more number of special courts as compared to the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act of 1989, where the litigation is much more higher than the Prevention of Corruption Act. So what is happening is that there is a lack of clarity with regards to the purpose of special courts, and this is something that needs to be done away with. So that is another analysis which has been given. Another analysis which has been given here is with regards to the backlog which the judiciary is facing, and this backlog is especially with regards to the subordinate judiciary, which has a pending of 2.8 crore cases approximately. So you can well see that how much is the backlog, and in this context what is indeed required is special courts and fast track courts. So that is something that has been analyzed. Not only that these courts should be set up, but also these courts should be made fully functional, which at present is not the case. So that is the important analysis in this editorial. Now two more additions is what I have included to bring a sense of completion to this article, though these 2 points are something that you will not find in the editorial. The first point that I have exclusively drawn here is with regards to the alternate dispute redressal mechanism. Now alternative dispute redressal mechanism is a mechanism to deal with these judicial backlog and increase judicial efficiency. The means of alternate dispute redressal mechanisms are mediation, arbitration, negotiation, public dispute redressal forums, and diplomacy. So these are some means through which alternative dispute redressal can be done, and this is one aspect which you should discuss here. Another very important analysis here is with regards to the think tank for judiciary. Now time and again we are seeing that judiciary is facing severe challenges, whether it is with regards to appointment of judges, whether it is with regards to preparation of roster, and now with regards to judicial inefficiency and backlog in special courts. But the issue with judiciary is that judiciary is lacking a think tank. Whatever thinking is being done by the senior most judges. So indeed, there is a need for an efficient, fully functional think tank for judiciary, and that is one important analysis here. Now, judiciary is important for this year. Judiciary is facing a lot of challenges, and that is going to be the relevance here. Now, coming to the next article, fighting forest fires. Now, the context here is with regards to the forest fires, and especially the Theni tragedy, which has happened recently. Now, in this context, some issues are what have been discussed. The first issue is with regards to the standard operating procedure. Now, you should have an idea that what actually happens whenever there is a forest fire. First and foremost, whenever there is a forest fire, this fire is going to get detected. Either this fire is going to get detected by the NASA, or it is going to get detected by the Forest Survey of India. Once this fire is detected, immediately a message is what is sent. The data that the exact location of this fire is something that is determined, and once this is determined, the information is immediately relayed to the divisional forest officer, who then comes into action and takes steps to curb the fire. So this is one standard operating procedure which is followed. Now, the approaches which are followed to curb the fire, these approaches, however, will never be asked directly, but the utility is that sometimes in a case study, it can be asked that you are the divisional forest officer and there is a fire in a forest. How will you act? Also, UPSC is now known for asking some innovative questions. For example, you are an officer and how will you deal with a rail accident? So such kind of issues are something that cannot be found in any particular book. The only source for such kind of questions and their preparation is newspaper. So that is what is making this editorial important. Now, the first approach which can be used is a technological approach. Now, what happens in this approach is that helicopters or ground-based personnel are used to spray fire retardant chemicals or pump water to fight a particular fire. But this is an expensive method, and this is one method that is not very much used in India. The second method is a containment method. In this, the fire is contained in compartments which are bordered by natural barriers such as stream, roads or ridges, or by fire lines. A fire line is simply a line which is cleared of all vegetation. So if there is fire, there is a containment of this fire which is done. Another idea or another approach is with regards to a counter fire. Now, what happens in a counter fire is that suppose there is fire in this particular region, then a line is what is going to be cleared, and this line is further going to be manned by human beings, by fire personnel. And then once the fire is seen approaching this particular cleared line of fire, the fire line, then a new fire, a counter fire is what is going to be set up. Once this counter fire is going to be set up, the oxygen in this particular region is going to be used by this counter fire. And whenever the two blazes will meet, immediately both the fires will get extinguished because of lack of oxygen. So that is one approach by which fires are curbed. Another approach is with regards to increasing the personnel itself. If there are enough people to fight a fire, then in that context, definitely a fire can be controlled. And this approach of more number of personnel is something that is used with the above two techniques in India. So that is the common method which India is using. Another is with regards to the mitigating damage. Now, this entire tragedy and this particular issue is also going to be important with regards to disaster management, because this is a disaster, either man-made or natural, but this is a disaster because we cannot at present predict that what was the cause of the fire. So either it could be termed as a man-made disaster or a natural disaster. So mitigation of this disaster is something that is going to be important. So preparedness is something that is vital in this regard. How can preparedness be done is, this can be done by increasing the number of firefighters, also by making the firefighters much more equipped with some equipments, for example, water bottles, backup supplies, food and water, proper shoes, rakes, spades, rechargeable torches. So these are some equipments which have been talked about in the editorial. So this is one way of preparedness. Another thing which has been discussed here is that there is a shortfall of personnel, especially during the fire seasons. So to mitigate that, what can be done is that seasonal labor and local villagers could be trained to fight fires, and that could be one means to plug the gap of personnel which does exist with the forest departments. Another thing which has been discussed is with regards to the funds. Now, this is an important analysis. What the editorial here is saying is that the funds that have been allocated to forests are largely spent in planting more number of forests or increasing the forest cover. But the issue is that the results of this are something that are not being seen. And whenever there is a forest fire, then already established resource is something that is lost. So a large amount of funds should be transferred from planting more forest to protecting the already existing forest. So that is something that should constitute the mitigation aspect. Another analysis which has been made is with regards to the Forest Act of 1927. Now, as per this particular act, one has to take a permission before entering a particular forest. Now, this is something that has been criticized in this editorial. The author is saying that this is a colonial act. As per this act, forests were something that were protected because during a war or during an emergency, timber was something that the government would have needed. And so, just to protect that particular resource, people were not allowed to go into the forest. Now, this is something that here in the editorial has been advocated that should be changed, and people should be allowed to enter the forest as tourists because they are not going to take any resource from the forest. But definitely you cannot directly replicate this idea. You should just add the idea that there is a need for more regulation in this regard, that whenever there is tourism that is happening in forest, it needs to be regulated. You cannot say that altogether tourism in forest should be banned, but definitely there is a case for regulating tourism. Forests have an important role to play in the quality of life of citizens, and that is something that cannot be denied. So in that context, definitely tourism should be allowed, but a regulated one. So that is going to be the analysis here. As I have mentioned, this is a unique article which can have some scope of replication. So that is going to be the relevance here. Now coming to the next article, after the emergency, the context here is with regards to the India-Maldives relation. Now the background here, as we have been discussing in the past also, is with regards to the crisis, the political crisis that is existing in Maldives. Now what had happened in Maldives is that the Supreme Court in Maldives had acquitted the opposition leader, the former president Mohammad Nasheed, and as a result of which the current president had announced a state of emergency. Now India had asked the current Maldives government to remove the emergency, but this was something that was not followed up, and now on its own will, Maldives has done away with the emergency. So that is something that you need to know in the background aspect. Now coming to the issues which are important, first issue is with regards to the state of crisis. Now even if this emergency is something that has been done away with, the crisis in Maldives is something that is continued. This is primarily because the judiciary in Maldives is not functional, and also the opposition in Maldives is exiled. So state of crisis is definitely not coming to an end. Another issue is with regards to the pushback for India. Now as I have mentioned, India had timely told Maldives to do away with the emergency or resolve the issues with the opposition, but a pushback is what India has received from the current Maldives government. The current Maldives government has criticized India for interfering and meddling in its internal affairs. So that is one setback for India, as well as for the India-Maldives relation as a whole. Another issue is with regards to China. Now this we have discussed in the past also. There are increased military exchanges with China and Maldives. Also there is a free trade agreement between China and Maldives. Also there are infrastructure investments which China is doing in Maldives. Also China had offered or proposed to broker negotiations between the government and the opposition. Now this is something that traditionally India would have done, but now China has taken that role. So this we have discussed in the past also. The most important analysis in this particular editorial is this point, that what is India's relevance to Maldives? This is something that has become questionable. India's relevance to Maldives, or for that matter the entire South Asia, is today waning, and this is one cause of concern for India. And this is despite the fact that India is the biggest power in the entire South Asian region. And this is something that is going to cause India to churn its foreign policy and look for alternative mechanisms. So that is one issue because of which I have included this particular editorial for discussion. Now, indeed, India, Maldives and India, South Asia is particularly very, very important for 2018 means. So that is the relevance here. Now, based on today's discussion, please try and attempt these questions within a word limit of 150 words. And with this, we finish today's discussion. I thank you all for watching and I hope to see you tomorrow.